This is Bloomberg Law with June Grasso from Bloomberg Radio.
More than 200,000 people have been denied gun permits since 1998 because of drug use. But now the Supreme Court will consider the constitutionality of the federal law that bans firearm possession by drug users and addicts. It's the law Hunter Biden was convicted of violating. But the Fifth Circuit Court of Appeals has concluded that the gun ban can't be applied to people unless they're using illegal substances at the same time they're found in possession of a firearm. My guest is Andrew Willinger, Executive Director of the Duke Center for Firearms Law. Andrew, tell us about the federal law at issue here in the Hamani case.
This section of federal law might sound familiar to people who have been following the court's Second Amendment jurisprudence over the past couple of years. This lists groups of people who, because of their status, are prohibited under federal law from possessing firearms or ammunition. And one of those groups was at issue in the Rahimi case. That's individuals who are subject to a domestic violence restraining order that meets certain criteria. But there are other groups as well, felons, for example, and then, as relevant to the Hamani case, individuals who are considered unlawful users of or addicted to a controlled substance. So that's the specific provision of federal criminal law that's at issue in this case, is a ban on unlawful drug users possessing firearms.
The Fifth Circuit found that a blanket ban is unconstitutional, but said the ban could be used against people accused of being high and armed at the same time. Explain the logic of that.
It is a little bit confusing because there really isn't a lengthy decision, because the circuit had decided an earlier case called Connolly, and all the judges said in this specific case is that, we're applying our ruling in Connolly and therefore find that as applied to this individual Hamani, the provision is also unconstitutional. But basically the approach that the Fifth Circuit has taken in these drug cases is to say that as a historical matter, the judges believe that there's support for applying this provision when somebody is under the influence of drugs and at the same time in possession of guns or ammunition. But when there's no proof that those two things were contemporaneous, that they occurred at the same time, then the judges have said that the provision cannot be applied. And that's what they decided in the Hamani case.
So the Justice Department is arguing that the law is valid. So they're arguing then for a law that restricts Second Amendment rights.
That's right. Yeah, it's a little bit of an interesting posture. But again, I think what this comes back to is the distinction between a facial challenge and an as-applied challenge. So the Hamani case deals with an as-applied challenge, and the government is saying, we think the Fifth Circuit got it wrong, but on these specific facts. So I think it's going to be a little bit of a delicate dance throughout this case as it works its way through the briefing and the oral argument before the Supreme Court, where I actually don't think that the current administration believes that 922G3, as the language has been interpreted, is constitutional in all of its applications, right? I don't know that they would say that this is constitutional as applied to somebody who's just, using marijuana on a regular basis. But they want to say in this case, because there are maybe exacerbating factors, it's not just marijuana, there's potentially other illegal drugs at issue, and there's a connection allegedly to foreign terrorism. That's not really relevant to the Second Amendment, but they're going to, I think, focus a lot on the as-applied nature and on the specific facts of this case.
The Supreme Court in 2022, in the Bruin case, ruled that any restrictions on firearms have to be consistent with the nation's historical tradition of firearms regulation. What is the history and tradition that the government is saying supports their position here?
The government, at least below in these cases in the Fifth Circuit, has basically rested on three categories of historical statutes or restrictions. So the first is the historical treatment of the mentally ill, and that's sort of an argument that maybe drug users are analogous in some way to those who are mentally ill, that it's some form of a temporary incapacitation. The second is more generally just laws that were based on a legislative determination that some group of people is dangerous and we're not going to allow them to have guns. And then the third is, and this kind of, goes in sequential order, the mental illness and the dangerousness laws are earlier. And then eventually you start to see laws that talk about alcohol and being intoxicated with alcohol. And those are also a category that the government has come forward with in these cases. And again, I think for each one, it's going to depend on this level of generality issue that courts have really been wrestling with under Bruin, which is how close do the historical statutes really need to be in order to uphold the modern law.
So the historical statutes go back to the 18th century when the Second Amendment was ratified. Do they also go back to the 19th century? I mean, what does the court consider an acceptable period of time for these historical comparisons?
Yeah, well, that's one of the really interesting aspects of these cases that the court has granted now, which is that in some sense, they're narrow questions, but I think in the background, you have this doctrinal uncertainty, and we're going to start to get some clues about questions like the one you raised, which is what's even the time period, right? How far back do you go? If something's enacted in the 19th century, is that too new? Like, does that not really inform the original meaning of the Second Amendment? In the Bruin case, the court seems to at least leave the door open to considering historical laws anywhere from around the time of the founding all the way up through about 1900. But there's really been a divergence in the courts of appeal in terms of what courts have done with this later in time history and how much emphasis they're putting on Reconstruction era history. And that's going to come up, I think, in these cases, actually.
To me, this illustrates the problems with originalism, making comparisons to a time when the laws were dealing with muskets. But I digress. So, Andrew, tell us about the defendant's arguments here.
It's really an argument for this contemporaneousness requirement. So the argument is that the historically correct way to think about this type of prohibition is that legislatures had the power to say if you are actively under the influence of some intoxicating substance and you're not acting in your right mind, at that point in time, you can be prohibited from having guns. But otherwise, just sort of evidence that you may have used drugs in the past isn't enough. And I think that's what they're going to say here. There probably also will be a lot of back and forth about how much work these other facts are doing, the connection to the terrorist organization, that shouldn't really be relevant. But I think what's happened, you mentioned the Hunter Biden case, the federal government doesn't charge this provision a lot. So they tend to charge it in sort of egregious cases. Hunter Biden, he's not just somebody who's using marijuana and happens to have a gun. He's going out and writing a memoir where he admits to this type of conduct. So I think there will be some discussion of this sort of how the provision's actually used, with the government maybe saying, look, we're not intending to really bring this type of charge, if somebody's just without any aggravating circumstance occasionally using marijuana.
Last year, the court did uphold a federal law that bars firearm possession by people under domestic violence restraining orders, even though there was no historical comparison. That was a reversal of the Fifth Circuit. Do you think that's where the justices are going with this case, that they took it to reverse the Fifth Circuit?
Yeah, so my best guess is that they did, that they took it tending to reverse the Fifth Circuit. I think actually it could be a close to unanimous decision, again, resting on this facial versus as applied issue, which was a similar issue in the Rahimi case, right, where they're sort of getting these cases with bad facts and saying, look, as applied here, this provision's okay, but we're not necessarily going to say that the unlawful user ban is okay if somebody's just a medical marijuana user and has a gun. So that would be my guess that they'll reverse here.
This is one of two Second Amendment cases the court is going to hear this term. Earlier this month, they said they'll hear a challenge to a Hawaii law that bars people from bringing firearms to malls, stores, and other private property without the owner's express permission. So tell us about this law, which is similar to laws in other states.
In the year or two after that Bruin decision, which set out this new test and also ruled that discretionary concealed carry permitting was unconstitutional. So in other words, basically said that states that had these stricter laws for determining whether somebody can have a concealed carry permit had to relax them. And so the 6 or 8 states that had those laws reacted ultimately by enacting new statutes, but they also instituted new application requirements, and they restricted where permit holders can carry their guns. And so typically what these laws look like, and what they look like in New York, California, and then Hawaii, was that they would have a long list of what's called sensitive places. So locations where guns are absolutely prohibited. You can't carry your firearm in a school, a government building, in a courthouse, and so on. And then a few states also did, as Hawaii did, what you can think of as switching the default rule for private property. So the default has always been that you are allowed to carry a firearm onto private property unless you are told otherwise. Think about businesses posting a sign that says no guns allowed, right? That's why they do that, because they have to specify if they don't want people to carry. But what these states have done is to say, we're going to flip that, and we're going to make the default that no carry is allowed. And if a business, for example, would like to allow a permit holder to carry their gun, they need to post a sign or otherwise say, yes, you're allowed to do that. But as a default, if they do nothing, a permit holder is not allowed to carry there.
And the court hasn't scheduled either of these cases for argument yet. Thanks, Andrew. That's Andrew Willinger of the Duke Center for Firearms Law. A note, Michael Bloomberg, the founder and majority owner of Bloomberg LP, the parent of Bloomberg Radio, is a donor to groups that support gun control, including Everytown for Gun Safety. Coming up next, the Supreme Court questions when police can enter a home without a warrant during an emergency. I'm June Grasso, and you're listening to Bloomberg.
If the police could not enter this house based on the facts that they knew, then I don't know when the police are ever going to be able to enter a house to prevent somebody from committing suicide.
Police didn't have a warrant when they entered the home of an Army veteran in Montana, but they weren't there to arrest William Trevor Case. They were there to help him. His ex-girlfriend said that Case had threatened suicide and had a loaded handgun. The police knocked. They yelled. They waited 40 minutes, and then they went in. The question before the Supreme Court is, what's the standard for police entering a home in an emergency? Justices from across the ideological spectrum suggested that the officers were right to go in this case. Here are Justices Samuel Alito and Ketanji Brown Jackson.
What more would they need here? They need to be able to look through the window and see him with a gun pointed to his head, or they need to see a dead body on the floor? What more did they need?
This person had a long history of threatening suicide, whether it be by cop or whether it be on his own or whatever. We have a long conversation, detailed, specific, with the girlfriend about circumstances that look like they're creating a pretty significant emergency.
And Justice Brett Kavanaugh questioned Case's attorney about the alternative scenario.
Well, if they, after deliberations, walk away and he commits suicide, I mean, what are you thinking then of the officers?
That would be unfortunate and tragic, yeah. But we are trying to strike a balance between
and the officers need some clarity, I would think, in circumstances like this about what they can do and what they can't do.
But there was no such clarity by the end of the arguments. Joining me is former federal prosecutor Robert Mintz, a partner at McCarter and English. Bob, so police normally need a warrant to enter a home, but there are some emergency situations that are exceptions. Tell us about that.
So there is a so-called emergency aid exception to the Fourth Amendment, which allows police officers to conduct a warrantless search if they have reasonable suspicion that there is an emergency and an immediate need to protect others or themselves from harm.
And tell us about the facts here, because Case ended up being convicted of assaulting a police officer.
The defendant in this case, William Trevor Case, was an Army veteran who had a girlfriend who contacted police suggesting that Mr. Case might be suicidal. Officers arrived at Mr. Case's house around 9 p.m., and they were familiar with his history of alcohol abuse and certain mental health issues. The ex-girlfriend had told police that Mr. Case had a loaded gun. He had threatened to harm police if she tried to send officers to his home. And she claimed before she hung up with the police that she had heard a pop and then silence and was concerned that Mr. Case had actually pulled the trigger. The officers arrived at Mr. Case's door. They yelled. They shined flashlights through the windows. They could see empty beer cans, an empty handgun holster, and a notepad with handwriting, which the officers believed at the time was a possible suicide note. After about 40 minutes, they entered through the unlocked front door, and when they went upstairs, they saw a closet curtain open. Mr. Case lunged forward, his arm outstretched, with what officers believed was a handgun. The officer fired one shot, striking Mr. Case in the abdomen. It turned out the handgun was found in a nearby laundry basket. The issue at trial then was when the defense tried to exclude the gun and other evidence of the confrontation from the trial judge overruled that defense and allowed the prosecution to present it to the jury, and he was convicted after a trial.
It seemed like the police had a lot of reasons to go in. How much more did the defense think they should have before they entered the house?
To put this in context, the Fourth Amendment of the Constitution prohibits unreasonable searches and provides protections for a person's home by generally prohibiting law enforcement from entering without a warrant. That is really set up in order to allow people to have privacy in their home in the context of a possible criminal case. The question that was facing justices in this case is what level of certainty must police have that an emergency is underway before entering a home without a warrant? Mr. Case's lawyers argued that it should be a high bar. They argued that it should be something called probable cause, which is what police officers need in order to get a warrant to search your home in the case of a criminal investigation. But here, this was not a criminal investigation. This was a circumstance in which they believed that there was an emergency and there was someone's life at risk inside the house. So the question is, what is the level of certainty that police officers need to have in order to enter the home without a warrant? And the defense argued that that level of certainty, in order to avoid needless and dangerous confrontations and to prevent police officers from circumventing the concept of probable cause, that there has to be probable cause that they believe that there is an emergency and that somebody is in imminent danger.
The state of Montana and the Trump administration argued that probable cause was too high a standard in these emergency cases. Montana's Solicitor General said that a stricter rule of probable cause would, quote, require police to stand outside a dying man's door. So what standard did they argue for?
The government argued that the justices should rely on a Supreme Court case from 2006. It was a unanimous opinion in a case called Brigham City versus Stewart, in which the Supreme Court held that police may enter a building without a warrant when they have an objectively reasonable basis to believe that an occupant is seriously injured or threatened with such injury. So in that case, they took it completely out of the context of probable cause, which really has an entire body of case law that talks about when police may enter a home with or without a warrant in the context of a criminal investigation, and said that here we're talking about imminent risk to somebody. It's not a criminal investigation. It's really a circumstance where police officers may come into a home in order to arguably save the life of somebody or save the life of somebody who may be with somebody who's in danger of hurting them. And in that case, the standard is objectively reasonable basis to believe that the occupant is seriously injured or threatened with such injury.
It seemed like justices across the ideological spectrum thought that the police had good reason to enter here.
Yeah, well, what's interesting here is that the Montana Supreme Court, which is the court that had just heard the case before going to the U.S. Supreme Court, sided with the state, but it was a 4-3 decision. And there were actually 3 judges on the Montana Supreme Court who dissented and said that for a warrantless search to be reasonable, the higher bar of probable cause must apply. And then they went further and added that there was no probable cause to believe Mr. Case was in imminent danger or in need of immediate assistance that would have justified the warrantless entry into the home. when the case went to the Supreme Court and was argued before the justices there was virtual unanimity that the standard that had been applied by the state was the correct one. First, for example, Justice Thomas noted that the issue of probable cause is a standard that is normally limited to the criminal context. This was not a criminal investigation. And Justice Robert joined in on that to say, when we talk about probable cause, we talk about probable cause that a crime is occurring. What standard would be used here when we're not talking about a crime, but about a risk of injury to somebody? And Justice Kagan also jumped in, saying that there is a full body of case law out there describing what probable cause is. It's not a self-defining term. It has been raised in many cases, and there is a full explanation in the criminal context of what constitutes probable cause. But this is something entirely different. And the justices all seemed to go back to the Brigham City versus Stewart case from 2006 to say that the standard of objectively reasonable basis for believing that somebody needs emergency help is the standard that should apply here. And Justice Alito and Justice Brown agreed, which doesn't happen very often. They both pushed back on the contention here of the defense lawyer that this was an unreasonable act by police. Justice Alito went so far as to say, if the police could not enter the house based on the facts that they knew in this case, then I don't know when police are ever able to go into a house to prevent somebody from committing suicide. The concern here is that if there is a legal standard of probable cause in order to go in under these emergency situations, that police officers may hesitate to go into a house when somebody's life is at risk. And they seem to weigh more in favor of protecting the life of an individual and allowing police officers more latitude to go in under these circumstances than they were about the privacy concerns of entering a house without a warrant.
So do you think that the justices will just announce a standard and that will be the end of the case?
If the Supreme Court decides to uphold the lower court, then there was some discussion about what comes next. In other words, there were some justices who said that they should simply rule that the lower court was correct and that the standard of objectively reasonable was properly applied, and that in this case, clearly the facts warranted the police entering the home. Justice Sotomayor and Justice Thomas, on the other hand, argued that it's the normal practice of the court, if they're not certain about a standard, and state a new standard, that it should be sent back to the Montana Supreme Court to determine whether, based on these facts, that objectively reasonable standard had in fact been satisfied. Justice Alito expressed some concern that in doing that, it might suggest to the lower court that this was in some way a close call, and could, he argued, have some kind of a chilling effect on police when they're trying to determine whether to enter a house to prevent somebody from committing suicide.
And the Supreme Court is usually protective of the expectation of privacy in one's own home. And we should point out here that some civil rights and privacy groups did line up behind the defendant in this case.
Mr. Case's attorney reminded the justices that police had entered Mr. Case's home without permission, without a warrant, or without even probable cause, and ended up shooting him in his own home. He argued that the reasonableness standard that the state was suggesting was so vague as to invite abuse and confusion by law enforcement. That was essentially the civil rights argument that Mr. Case's lawyer was arguing, and a number of prominent civil rights organizations came out in favor of the defense, arguing that the warrantless search here was a violation of the Fourth Amendment, and they were more comfortable with the probable cause standard to allow police to enter a home, even in a case where there was an emergency and there was some concern for the safety of an individual inside the home.
This is one case this term where it appears, you never know, but it appears that we know how it's going to turn out. But we shall see. Thanks for joining me, Bob. That's former federal prosecutor Robert Mintz of McCarter and English. Coming up next on the Bloomberg Law Show, why President Trump wants $230 million from the Justice Department. And Trump may give you a pardon, but that doesn't mean the banks will. Remember, you can always get the latest legal news by listening to our Bloomberg Law podcasts wherever you get your favorite podcasts. I'm June Grasso, and you're listening to Bloomberg.
Because of everything that we found out, I guess they owe me a lot of money.
$230 million. That's the amount of money President Donald Trump says he's entitled to as compensation for the investigations into whether his campaign colluded with Russia in the 2016 election and the search of his Mar-a-Lago property for classified documents in 2022. Trump has filed claims with the Justice Department in that amount, and even he seemed to acknowledge how odd it is that he'll have the final say on his compensation.
And, that decision would have to go across my desk. And it's awfully strange to make a decision where I'm paying myself.
My guest is constitutional law professor Harold Krent of the Chicago-Kent College of Law. Hal, this is another instance where I'm going to use the word unprecedented.
So this is the most, on the one hand, amazing chutzpah or hubris that any of us have seen, because what the president is saying is because the former administration investigated my actions with classified documents, investigated my role in the Russia supposed influence of the 2016 election, that they've committed torts. They've committed torts against me, violated my privacy rights, malicious prosecution, and therefore, because of those torts, I can recover under the Federal Tort Claims Act. Federal Tort Claims Act is a government's waiver of immunity from tort suit in particularly defined circumstances. And under the Federal Tort Claims Act, before you can sue in court for a tort, you can file an administrative claim before the agency that one asserts caused the individual harm. So what this is an administrative claim prefatory to a potential Federal Tort Claims Act lawsuit saying that I was injured by torts through this investigation in both these two contexts.
According to the Justice Department manual, settlements of claims against the department for more than $4 million must be approved by the Deputy Attorney General or the Associate Attorney General. The Deputy Attorney General is Todd Blanche, who represented Trump in his criminal cases, and the Associate Attorney General is Stanley Woodward, who represented Trump's co-defendant. So the ethical issues are apparent. You don't have to be a lawyer to see them, but who's going to stop them?
Not you or me. Why this is so unbelievable is then it's the Justice Department that gets to decide whether to pay the claims or not. So that people he can fire, his own former personal attorneys, then will sit on this issue about whether he deserves compensation. So there's no court review, there's no public review. This is insider. It's like opening up the Treasury, let me scoop out as much as I want. That's what this is in essence, and it's just outrageous. But let me also say that what's amazing about this, that I'm sure the president hasn't considered, is this is opening up the same process for those who've been injured by ICE. Because what people are saying is the only type of compensation allowed will be for people to go before the Federal Tort Claims Act and basically allege claims of brutality, false arrest, malicious prosecution, privacy rights invasions by ICE officers. And if I were defending those ICE officers, I would say, well, look, the president's done the same thing, almost the same theories. And if the president says we can use the Federal Tort Claims Act for his own purposes, then obviously people who've been injured by ICE officers should be able to use the mechanism despite the defenses in the Federal Tort Claims Act itself.
A Justice Department spokesperson said, in any circumstance, all officials at the Department of Justice follow the guidance of career ethics officials. However, Attorney General Pam Bondi fired the department's top official responsible for advising the Attorney General and the Deputy Attorney General on ethics issues in July.
So, yeah, we don't have a top ethics official anymore. There's just no break. There's no internal guardrail on this. It just shows the problem of having no type of separation or independence.
Will we know when this happens, or is it all internally done within the Justice Department?
The actual payment has to be in a record. So there will be legally cognizable means to say whether or not this happened. But the deliberations don't have to be in public. So we're not going to get a sense of who said what. There's not going to be like briefs before a court. This is an internal decision by his deputy and associate as to whether and how much to pay him. But we will know that taxpayer monies will be allocated to his bank accounts. And, who knew that being president would be so profitable? This is just another, ingenious way that President Trump is bound to line his own pockets at the expense of the American taxpayer.
I'll say it again, unprecedented. Thanks so much, Hal, for joining me. That's Professor Harold Krent of the Chicago-Kent College of Law. Let's turn now to President Trump's sort of pardoning spree. Trump has issued more than 1,600 pardons and commutations in the last 9 months. Last week, it was former convicted Republican Congressman George Santos. This week, it was the convicted founder of the crypto exchange Binance, Changpeng Zhao.
I don't know. He was recommended by a lot of people. A lot of people say that, are you talking about the crypto person? A lot of people say that he wasn't guilty of anything.
But it's one thing to be cleared by the president. It's another thing to be cleared by the banks. And some of the people pardoned during Trump's first term found that out when they were debanked. Joining me is Bloomberg senior reporter Tom Schoenberg. Tom, Republican fundraiser Elliot Broidy, who was convicted for violating a lobbying law, and former CFO of social media company X, Mahmoud Reza Banki, who was convicted of making false statements, were both pardoned at the end of Trump's first term. But explain how those White House reprieves only go so far.
So both, Mr. Broidy and Mr. Banki kind of recently, within the, last year or so, sought banking services. Both had applied, for credit. Broidy from American Express, Banki from JP Morgan, and were denied. And as they pushed for explanation as to why, in both instances were told that it was due to a criminal record that they had, that was tied to the pardon that they received from President Trump in his first term. With Banki, that also meant he had applied for a credit card with Bank of America and a 529 account that involved Fidelity, and the same situation. He was denied accounts or denied access to credit.
Is there really a term, debanked?
There is now.
Tell us what that means.
It's a good question, because when I was interviewing people for the article, including Liz Oyer, who is the former pardon attorney at the Justice Department, she asked, well, what is debanking? Because until recently, it wasn't really a term, but it is now, and is also used in both these lawsuits that were brought by Mr. Broidy and Mr. Banki.
Is a pardon meant to erase the legal conviction on your record, or is it meant to wipe the slate clean?
Really, in terms of how it's been interpreted, erases that legal stain of the conviction, right? And I think in terms of financial services, what these cases are sort of raising to an extent is, does that necessarily override these risk assessments of private lender that are required under law to prevent money laundering and to know their customer, which usually is a look back on their history, both financial but also criminal history?
Some MAGA people think that conservatives are being debanked for their political beliefs, and you write that it's become an obsession with some, including President Trump.
Yes, President Trump and the Trump Organization has sued Capital One Financial Corp, making accusations that they had improperly kind of closed hundreds of accounts that the Trump Organization had. And Capital One denied any sort of wrongdoing. They moved to have the case dismissed. That's in front of a judge right now. And the argument on their end is that they had the right to cancel accounts based on the contracts that they had for those accounts. It's been a personal issue for the president. Additionally, in August, he issued an executive order directly at this issue called Guaranteeing Fair Banking for All Americans, in which he calls out the quote-unquote debanking of, specifically conservatives and others for whether political or religious reasons, and orders financial regulators to remove some of the, standards they had in reviewing accounts at institutions, as well as looking back and see whether any people's accounts had been closed due to whether political, religious reasons or some other sort of unfair determination.
Since the executive order, have banks been making changes?
Some got out ahead of that. JP Morgan, beginning even after the election last year, had started making changes both in public materials and then in their own policies, specifically noting that it would not base decision-making on accounts on religious or political views. So you're seeing it there. You're even seeing it in terms of these cases. Mr. Bonnke, one of the things that happened after he brought his case over not receiving credit from J.P. Morgan, it happened that he had two accounts at another institution called First Republic Bank, which in 2023 had collapsed and was taken over by J.P. Morgan. So initially, they had moved to close those two accounts, with one of their anti-money laundering executives telling the court due to his earlier conviction. Once this lawsuit was sort of underway, and he moved for a temporary restraining order to stop them from closing those accounts, J.P. Morgan kind of reversed itself. They told us that they looked at that appeal that he was successful on with some of the criminal accounts. They also looked at it had been 15 years to them, that this time had gone by without any other sort of criminal allegation against him. And so they're going to keep those accounts open.
Did Brody ever get an American Express card?
Unclear. At the moment, this is still in litigation. In fact, American Express is telling the judge that they need to dismiss this case because these card member agreements, account agreements, usually require that disputes be handled in arbitration.
And explain the perspective of the banks on this.
It's really a liability issue for the banks that they're making these assessments. They have to comply under the law, that the people who they're giving access to the U.S. financial system to are not going to be using it for illicit purposes. So you have it twofold. One, if someone's a fraudster, the bank itself could later be sued by victims claiming that they didn't do enough. They can also be penalized by the government for not abiding by all the rules and regulations to ensure that we have a safe banking system. So if somebody has some type of financial crime on the record, that's going to be looked at very closely by the bank. In terms of how aggressive they are in this space, talking to a number of defense lawyers, a lot of times people lose their banking even at the first sign of an investigation, let alone a conviction. So, it's quite common for a bank to receive a subpoena even for records of somebody related to a case and immediately cut off an account. So someone might learn they're under investigation just by losing access to their banking. It's kind of a large wave in terms of, investigation and losing banking.
It's really been a fascinating conversation. Thanks so much, Tom. That's Tom Schoenberg, Bloomberg senior reporter. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.